Start. When learned counsel try their best to render an otherwise simple proposition into something very troublesome, it is only then that the glorious simplicity of the opinion of my learned brother can be best appreciated. While agreeing with most of what my learned brother has held, I would like to add a few paragraphs which throws into sharp relief the actual dispute between the parties. The entire case revolves around a short compass as to what would be the meaning which the court is to ascribe to the wards in section 25 of the Guardians and Wards Act 1890. Title of guardian to custody of wards. Number 1. If a ward leaves or is removed from the custody of a guardian of his person, the court, if it is of opinion that it will be for the welfare of the ward to return to the custody of his guardian, may make an order for his return, and for the purpose of enforcing the order may cause the ward to be arrested and to be delivered into the custody of the guardian. Both the learned advocates tried to impress upon me that the magic words are in reality those contained in a few sections of the Guardians and Wards Act 1890 pertaining to jurisdiction of the district court. They both draw inspiration from firstly section 4 subsection 5 and then section 9 read with section 4 of the Act of 1890. Since both the parties have placed great emphasis on these provisions, even if according to me the true construction of section 25 of the Act 1890 is to be discovered from the context of that section alone, I find myself reluctantly forced to deal with those sections to which learned counsel have drawn my attention. Section 4.4 read as follows. 4. Definitions in this act, unless there is something repugnant in the subject or context. 1. Minor means a person who, under the provisions of the Indian Majority Act 1875, 9 of 1875, is to be deemed not to have attained his majority. 2. Guardian means a person having the care of the person of a minor or his property or of both his person and property. 3. Ward means a minor for whose person or property or both there is a guardian. 4. District court has the meaning assigned to that expression in the Code of Civil Procedure 14 of 1882 and includes a high court in the exercise of its ordinary original civil jurisdiction. 5. The court means A. The district court have jurisdiction to entertain an application under this act for an order appointing or declaring a person to be a guardian, or B. Where a guardian has been appointed or declared in pursuance of any such application. 1. The court which or the court of the officer who appointed or declared the guardian or is under this act deemed to have appointed or declared the guardian, or 2. In any matter relating to the person of the ward, the district court having jurisdiction in the place where the ward for the first time ordinarily resides, or section 9 reads as follows. 9. Court having jurisdiction to entertain application. 1. If the application is with respect to the guardianship of the person of the minor, it shall be made to the district court having jurisdiction in the place where the minor ordinarily resides. Para 2. If the application is with respect to the guardianship of the property of the minor, it may be made either to the district court having jurisdiction in the place where the minor ordinarily resides. Stop.